All right, so here we are. We've talked about the executive branch. We've talked about the legislative branch, the Constitution that sets it all up. We're going to focus today on the third branch of government, and that branch is the judicial branch. Of course, the legislative branch makes the laws, the executive branch enforces the laws, and the judicial branch interprets the laws. Sometimes also we'll say that the judicial branch applies the laws, and that means like applies it in a particular case. Obviously, laws are written words, sentences and paragraphs, and so we turn over to the third branch of government, the judicial branch, the power, the ability, the job to read those laws and decide what exactly those words mean. Just as an example, we say you have the freedom of speech. What exactly does that mean? Does that mean I can wear a Make America Great hat to school? Does that mean that I can say that the president is a jerk? Does that mean that I can stand up in my teacher's face and curse him out? All these things would be related to freedom of speech, and it would ultimately be up to the judicial branch to determine what exactly freedom of speech means. The judicial branch is made up of the federal court system. The federal court system actually has three levels. The Supreme Court up on the top. In the middle, we have what we call the circuit courts, or sometimes also called the appellate courts, because that's where appeals happen. And then below that, we have the district courts. At the end of this little presentation, I'll show you a graphic map that'll sort of hopefully give you a visual for how these things work. The lowest level of courts is the district courts. So you take the whole United States and you divide it up into little segments. Some states have multiple districts within them. Some states only one. But when there's a conflict where a federal law or the Constitution or a right from the Bill of Rights, the first place that this would go is the district courts. So these are the lowest level of courts, and then they would make their ruling. The middle courts are the circuit courts. If one side or the other in a district court decision doesn't like the decision, then they can appeal and they can go to the circuit courts. Again, sometimes also called the courts of appeal. Multiple districts are covered by the circuit courts, so the circuit courts are kind of like bigger regions than the districts cover. Eventually, if both sides, again, don't like the outcome of a particular decision, they can appeal it to the highest court, the Supreme Court, and it would be the Supreme Court that could make the final ruling, overruling either circuit or district courts, as well as state courts and courts from smaller regions like the states. Let's talk a little bit about Supreme Court justices. There are 9 members of the Supreme Court. They have a Chief Justice. The Chief Justice is basically leads the court, but doesn't have any really more powers than any one judge or the others. It's just that that's the person who leads the court. All federal judges, including the Supreme Court justices, serve for life. We talked a little bit about this during the executive branch presentation. So the president appoints the judges. They serve for life, and the idea is we want them removed from the political process. We don't want judges to be worried about being reelected. We don't want them to be worried about being influenced by public opinion. We just want them to read the laws, to read the Constitution, and apply them in particular instances. Besides serving for life, they also can't have their salaries reduced. This was the way back in colonial times that colonial governments would control judges, is by perhaps withholding their salaries if the judges were doing things that the colonists didn't like. As I mentioned the previous day and even just a moment ago, federal judges and Supreme Court judges are appointed by the president with the advice and consent of the U.S. Senate. So basically, once the president makes his or someday her choice for a U.S. senator, for a judge, a federal judge or a Supreme Court judge, then that judge goes through a vetting process where the Senate will research the judge, the Senate will debate and discuss and eventually vote on the judge, whether or not they accept that judge to be appointed to the federal court system, including the Supreme Court. The ultimate power of the judicial branch is what we call judicial review. We learned a little bit about this from way back in American history during Thomas Jefferson's presidency, the transfer from John Adams to Thomas Jefferson's presidency. And so this power is the power to decide if something is constitutional or not. So basically the Supreme Court reads a law, or the Supreme Court interprets the application of a law and decides whether or not that law has been applied properly according to the Constitution. If it has not, then they will strike it down, and whether it's a law or whether it's an action by the executive branch, then they will strike it down, and for example, if somebody's been put in jail for something unconstitutional, then that person would be released from jail. The precedent that established this power was the court case Marbury versus Madison. Without going into much detail about it, what's interesting about the judicial branch is basically in the court case of Marbury versus Madison, the court established the power of judicial review for itself. It doesn't say anything about judicial review in the Constitution. This is just the first time the court asserted that authority. They basically ruled on behalf of Thomas Jefferson's presidency, so Thomas Jefferson didn't fight them, but at the same time, this became the precedent, meaning the example that's later followed throughout American history. So essentially, the Supreme Court and federal courts have gained for themselves this power of judicial review. Oftentimes, judicial review involves interpreting the Bill of Rights. Obviously, the Bill of Rights have all of our rights listed in them that, again, we're born with. And so, as I mentioned as in my little intro here, for example, the freedom of speech. It's in the Bill of Rights, and so this would be something that the Supreme Court would interpret. As I mentioned, I'd end here with a graphic. Here's a graphic showing. You notice the lines dividing up the various states. Those would be the district courts, right, with the S and the M, those are district courts. Then the numbered sections, the way it's kind of broken up, those are the circuit courts. And then finally, the Supreme Court, found in Washington, D.C., would be the ultimate court at the top of this entire system. So again, depending upon where the violation or where the dispute over the Constitution or federal law occurred, that's where it would start in that district. Then if one of them didn't like it, one of the people in the decision didn't like the decision, they can appeal it to the circuit, and if they didn't like it in the circuit, they can appeal it to the Supreme Court. There's a little bit more to the court system and under the judicial branch as far as jurisdictions and stuff, but we'll save that for AP US government. Thank you all for listening, and I hope this helps you study for your upcoming quiz and tests.